I will place a lion against you.
Mr. Pendleton, that is a threat. A not guilty plea will be entered.
This is the collision at the heart of sovereign citizen belief.
The paper law myth. I want to start in the place where this myth usually runs out of road, a courtroom. Picture with me. Someone stands before a judge and begins reciting a kind of modern legal folklore. They say they are not the person named on the charge sheet. They say they were not driving, they were traveling. They do not consent to the court's jurisdiction. And that name in capital letters, that is not them, they say, that is a corporation, a fiction, a straw man, which is impressive because most of us struggle to keep track of one identity before breakfast. Good evening, folks. Welcome to Bernette's Bizarre but True Tales. I'm your host, Bernette, and tonight I'm taking you into the strange world of sovereign citizens, a world where some people believe the law can be escaped with the right words, the right documents, and the right ritual at exactly the right moment. Basically, legal Hogwarts, but with worse stationery. Most of the time, I imagine the judge listening patiently, maybe even wearily, and then the ordinary machinery of law just keeps moving. The license offense remains, the tax bill remains, the mortgage arrears remain. Sometimes the sentence even gets worse. Which is awkward, isn't it, if your whole legal theory depends on the court disappearing the moment you say the magic words. But inside the myth, every defeat can be turned into confirmation, proof that the gatekeepers are corrupt, proof that the court is hiding its true nature, proof that the correct spell just has not been spoken in the correct order yet. A bit like assembling flat-pack furniture, except the wardrobe is a custodial sentence. So I'm going to tell this as a myth of paperwork, a story about people who came to believe that colons, hyphens, stamps, thumbprints, and carefully arranged words could open a secret door in the law. And I want to take you into that story through one of its strangest figures, David Wynn Miller, a former tool and die welder who became a self-declared judge, a tax protester guru, and the creator of a pseudo-legal language he called quantum grammar, because apparently ordinary grammar was not already causing enough problems. Miller died in 2018, but the ideas he helped popularize did not die with him. They moved from hotel conference rooms and photocopied legal packets into encrypted chats, live streams, short-form videos, debt discharge courses, anti-lockdown protests, and mortgage rescue schemes. What once looked like a fringe American tax protester subculture now appears in council tax disputes in Britain, foreclosure cases in Australia, roadside stops in Canada, and Telegram channels where conspiracy movements overlap and recombine. So the question I keep coming back to is not just, why would anyone believe something so fragile? The deeper question is, what does this myth give them? Why does a movement built on failed court arguments keep growing? Why do people facing real legal or financial danger turn to imaginary law? And why, after 2018, did this paper mythology become more visible, more international, and more fluent in the language of the internet? Because if there is one thing the internet loves, it is a confident man with a template and absolutely no follow-up data. Act 1, a movement built from distrust. To understand Miller, I have to step back for a moment. Sovereign citizen beliefs did not begin with him. They grew out of older anti-government tax protester and militia-adjacent movements in the United States. And at the center of it all is a claim that sounds deceptively simple. The government has no legitimate authority over you unless you consent. Once you accept that claim, a whole alternative legal universe opens up. In that universe, the state is not a public authority. It is a corporation wearing a mask. Courts are not ordinary courts. They are commercial or maritime chambers. Laws are not binding duties. They are hidden contracts waiting to be refused. A traffic stop is not enforcement. It is a ritual of consent. A summons is not a command. It is an invitation from a paper kingdom. Conveniently, that paper kingdom seems to appear most often when someone has received a fine, a tax bill, or a court date. Funny how the hidden empire never appears when the bins need to be taken out. Every myth needs a double. And in sovereign citizen ideology, that double is the straw man. Believers are told they are not one person, but two. First, the living, breathing human being with natural rights. Second, a legal persona is supposedly created by the state at birth. In this worldview, a birth certificate is not simply a record. It becomes the moment a shadow self is created, a paper identity that can be taxed, fined, licensed, sued, arrested, and so the myth claims used as collateral for government debt. As I follow the belief, I see followers being taught to look for proof of this hidden split in the most ordinary places: driving licenses, tax bills, summonses, bank statements, court papers. If the name appears in all capital letters, they are told that is not really them. That is the straw man, the corporate fiction. The living person they believe can separate from that fiction through declarations, stamps, thumbprints, altered punctuation, and carefully staged refusals of consent. This asks us to believe that the whole machinery of modern law hinges on typography. Bold, certainly. Legally useful? Not so much. If fonts had that much power, Comic Sans would have been banned at The Hague. The trouble is the myth fails the moment it touches real law. Capital letters do not create a second person. Birth certificates do not create secret government accounts. You cannot step outside criminal law, road traffic law, taxation, or court procedure by changing punctuation or refusing to acknowledge a name. And yet the story survives because it offers relief. It says the system controls only a paper copy of you, and that somewhere, if you can file the right document, there is a hidden door out. That is the part one want to take seriously, even when the theory itself is nonsense. That is the emotional hook. The myth tells people that failure is not failure. It is evidence of hidden power. It tells them bureaucracy is not merely confusing, it is malicious. It tells them legal language is not technical, it is a trap. And into that atmosphere stepped David Wynn Miller, a man who looked at ordinary sentences and apparently thought, no, these need more punctuation and fewer consequences. Act 2, David Wynn Miller, the origin story. When I look at David Wynn Miller's story, I see someone who turned biography into legend. He was born in the late 1940s and worked as a tool and die welder before becoming known in sovereign citizen circles. He had no recognized credentials in law, linguistics, or mathematics, but he presented himself as someone who had discovered the hidden architecture of language, the secret grammar underneath reality itself. Miller's biography is difficult to separate from Miller's mythology because the mythology was part of the product. In his own accounts, he claimed that at around age 25, he underwent a catastrophic medical procedure. He said a surgeon mistakenly removed his kidneys and adrenal glands, that he died for about 30 minutes, and that his heart restarted while his body was being prepared for autopsy. According to Miller, this experience transformed him. He claimed his IQ rose to 200, that his endorphin levels became dramatically elevated, that his body temperature changed, and that he stopped aging. These claims were extraordinary and unsupported, always a useful combination if you are building a legend rather than submitting evidence. But their factual accuracy is not the only issue. What matters for understanding the movement is how the story worked. It is less medical history and more superhero origin story. If the superpower is confusing county clerks, that medical rebirth story gave Miller the aura of a prophet. It made him sound like a man who had crossed the threshold, come back with forbidden knowledge, and could now see through the veil of ordinary reality. I am skeptical of the claims, to put it mildly, but I can see how the story worked. In movements built on distrust, a miraculous origin story explains why outsiders cannot understand the teacher and why followers should trust him over institutions. But the more concrete origin of Miller's legal obsession appears to have been a series of personal defeats in court. In the 1980s, he went through divorce and custody proceedings. He represented himself repeatedly and lost. Those losses became the interpretive engine of his theory. He did not conclude only that the courts were difficult, expensive, or emotionally punishing. He concluded that the entire legal system was operating through corrupted language. This is where I would bring in an expert voice, someone who can explain how, in pseudo-law movements, a personal grievance often becomes a universal theory. A person loses a case, but instead of interpreting that loss within ordinary legal procedure, they decide the procedure itself must be fraudulent. Miller's answer was not to become a lawyer. His answer was to build a rival legal language. Act 3, quantum grammar. And this is where the myth becomes linguistic. Miller called his system correct sentence structure communication syntax language, better known as quantum grammar. The name sounds scientific, almost mystical, But the promise underneath it was simple. Ordinary English was defective, dangerous, and manipulated. His language, he said, was mathematically correct and therefore impossible for courts to defeat, which is a bold claim from a system that sounds like someone dropped a law textbook into a blender. In Miller's world, grammar became a battlefield and punctuation became ritual equipment. Adjectives, tenses, pronouns, and ordinary sentence structures were treated as suspect. Colons and hyphens were used to reformat names and statements, as though the marks themselves could separate the living person from the paper double. Miller even styled his own name with punctuation, David Wynn Miller, as if identity could be purified by syntax. It is hard not to admire the ambition. Most people use punctuation to clarify meaning. Miller seemed to use it to challenge the operating system of reality, and somewhere a semicolon quietly asked not to be involved. When I read Miller's written language, it is dense, repetitive, and almost impossible for an outsider to parse. But difficulty can look like depth. To believers, that strangeness made it feel technical, even sacred. It sounded like law, mathematics, code, scripture, and spell work all at once. That was its power. It did not need to be clear. It needed to feel hidden. Miller claimed his method could do extraordinary things, defeat court actions, cancel taxes, discharge debts, and expose fraud by judges and governments. He gave seminars, sold materials, and presented himself as a kind of world-level judicial authority. His followers were not just buying grammar lessons, they were buying the promise that language could reverse power. A remarkable upgrade, really, from sentence structure to global jurisdiction in only a few seminars. Most language courses promise holiday conversations. This one promised to overthrow municipal governance. And this is where the story becomes more serious. Many people drawn to these teachings were not casually experimenting with legal theory. They were facing foreclosure, bankruptcy, tax enforcement, family court conflict, criminal charges, or eviction. If you feel trapped by institutions, then someone who says you can beat this with the right document is not just eccentric, they are persuasive. But when I follow the court records and the consequences, the spell does not work. In actual courts, Miller's system was rejected as unintelligible, frivolous, or legally meaningless. Judges did not treat punctuation as jurisdiction. Banks did not accept homemade debt instruments. Police did not recognize declarations of non-consent as exemptions from road traffic law. The promised escape route led many followers deeper into the consequences they were trying to avoid. Reality, inconveniently, had not agreed to the terms and conditions. Act 4, pseudo-law as a business model. One reason I think these ideas survive repeated legal failure is that myths can become markets. The movement has long had gurus, people who sell seminars, templates, filing packages, books, coaching calls, private memberships, or document preparation services. The product is usually not a legal representation in any recognized sense. It is pseudo-legal confidence. It tells the buyer that their intuition is right, the debt is fake, the government is illegitimate, the court has no power, and the right document will prove it. This business model depends on ambiguity. If the customer loses, the guru can say the ritual was performed incorrectly, the wrong wording, the missing phrase, the failed reservation of rights, the accidental consent, the corrupt official. Failure rarely discredits the theory. It often creates demand for the next document, the next seminar, the next key. In other words, if the magic does not work, the solution is apparently to buy a better wand, or at least the premium wand available in the members-only portal. That is why courts and legal commentators often call these systems organized pseudo-legal commercial arguments. Organized because people learn them from networks and teachers. Pseudo-legal because they imitate law without being law. Commercial because very often someone is selling the method. What remained was the market. People in distress, people suspicious of institutions, people searching for a way out, and influencers willing to monetize certainty. Act 5, 2018, and the digital afterlife. When David Wynn Miller died in 2018, the irony was hard to miss given his claims of biological immortality. Death, it seems, had not been properly served with notice. But myths do not always need their prophets to survive. For this movement, his death marked a transition. The man was gone, but the method had already found the internet. By the late 2010s and early 2020s, sovereign citizen ideas were no longer dependent on seminars or obscure forums. They could be clipped, captioned, simplified, and circulated. A complex pseudo-legal theory became a short video. You do not have to pay this debt. Ask the police officer if they are acting under oath. Write accepted for value. Say you do not consent. Use this template, because if there is one thing the legal system was apparently waiting for, it was a downloadable PDF and a confident stranger on the internet, preferably one filming from a car, because that is where jurisprudence truly flourishes. Miller's full quantum grammar was too obscure for most people to adopt in detail, but the relics survived: the colons, the hyphens, the red ink, the postage stamps, the suspicion of capital letters, the idea that ordinary language is a trap and that documents can become weapons. Then came the pandemic, lockdowns, health regulations, mask requirements, vaccine debates. Economic anxiety, isolation, and institutional distrust created ideal conditions for anti-authority narratives to spread. Sovereign citizen ideas fused with anti-lockdown activism, anti-vaccine conspiracy narratives, QAnon-adjacent beliefs, and broader suspicion of global institutions. On Telegram and other platforms, researchers have documented sovereign citizen communities discussing pseudo-legal tactics, anti-government claims, property schemes, and overlapping conspiracy narratives. One large-scale analysis of sovereign citizen activity on Telegram examined hundreds of thousands of messages and found signs of ideological overlap with QAnon-style conspiracy thinking. In Britain, related Freeman on the land ideas became more visible in disputes over council tax, mortgage possession, public health rules, and local authority enforcement. The language differed slightly. The references shifted toward Magna Carta, common law, and parliamentary sovereignty. But the emotional structure was the same. I do not consent. Therefore, the law cannot reach me. The digital age did not invent sovereign citizen ideology. It made it portable. It turned the myth into a clip, a template, a live stream, a private group. And perhaps most importantly, it made failure less visible than performance. A viral roadside confrontation can be edited into victory, even if the legal result is arrest, fines, or imprisonment. The clip ends before the consequences begin. This is where I would use an archive-style reading to make the point plainly. The advice spread online is often presented as legal education, but it is usually detached from any recognized legal framework. Viewers may not see the failed cases, the cost orders, the repossessions, or the criminal penalties that follow. And that is the documentary problem at the heart of this story. The belief spreads through spectacle, but the damage happens quietly. Act 6, Why People Believe. I know it is easy to mock sovereign citizen arguments. Some of them collapse almost instantly under scrutiny. A gold fringe flag does not turn a courtroom into a ship. A birth certificate is not a secret bank account. A name in capital letters does not create a separate corporation. A postage stamp does not transform a defendant into a diplomatic authority, though to be fair, it would make administrative law much more visually interesting. Imagine the judge saying, "Objection sustained," but only because that stamp is adorable. But ridicule alone misses something important. People do not usually enter these movements because they love paperwork. They enter because the myth arrives at a moment of pressure. It offers a map when the real world feels unreadable. If you are facing eviction, the movement says the mortgage may be fraudulent. If you are in debt, it says the debt can be discharged through hidden procedures. If you feel ignored by the government, it means the government has been illegitimate all along. If the legal system feels incomprehensible, it says that it's because it was designed to be a trap. In that sense, sovereign citizen ideology is not merely a set of false claims. It is a coping mechanism, a political theology, and a marketplace. It gives believers enemies, rituals, scripts, status, and community. It turns helplessness into apparent expertise. It gives the lost a map, even if the map leads them further into the maze. David Wynn Miller's contribution was to place language at the center of that transformation. He told people that the system's power lived in grammar. If that were true, then a person without money, legal training, or institutional power might still win by mastering syntax. That is a deeply seductive promise. It is also, unfortunately, not how courts, contracts, taxation, road traffic law, or basic reality work. Reality remains stubbornly unbothered by sentence diagrams, but the promise is false. And false promises are not harmless when they guide people away from real legal advice, real negotiation, real debt support, real housing advice, or real representation. Act 7 Consequences. As I follow this movement, I keep coming back to the consequences. They can be administrative, financial, legal, and sometimes violent. At the lowest level, it can mean wasted time. Councils, courts, lenders, and public agencies receiving long pseudo-legal letters that require responses even though the arguments have no legal merit. At a more serious level, it can mean individuals sabotaging their own cases. A person who refuses to recognize the court may miss deadlines. A person who files incoherent paperwork may lose the chance to raise a valid defense. A person who believes a debt has been magically discharged may ignore enforcement until the costs grow larger. In some cases, the movement also encourages confrontation. Police roadside stops become stage tests of jurisdiction. Evictions become battles over imaginary common law authority. Public officials become targets for harassment, liens, threats, or accusations of treason. It is important not to treat every believer as violent. Many are not. Many are frightened, confused, or exploited. But the ideology can lower the threshold for confrontation by telling adherents that officials lack legitimate authority and that compliance amounts to surrender. That is why law enforcement agencies, legal scholars, local authorities, housing advisors, and courts increasingly pay attention to pseudo-law, not because every strange document is a threat, but because these ideas can turn ordinary legal stress into a radicalizing experience. Act 8. Inside the courtroom. Let me put you inside the room. It is late on a Friday afternoon in a small courtroom, the kind where every sound seems louder than it should. The fluorescent lights buzz above the benches. A clock ticks against the back wall. The coffee beside the clerk has gone cold. Most of the cases have already been dealt with, and the room has that tired, end-of-week stillness. Even the carpet looks like it has heard too many mitigation speeches. Then the next name is called. The case is the State versus Arthur Pendleton, an unregistered vehicle driving without a license. On paper, it is routine. In the room, it does not feel routine. Arthur rises slowly from the back row with a bulging folder pressed against his chest. The folder is thick with tabs, envelopes, red ink notices, photocopies, and stamped pages. Before he reaches the front, people have already started watching him, because nothing says straightforward plea hearing, quite like arriving with enough paperwork to challenge the constitutional order of a small island nation. Somewhere, a photocopier gave its life for this moment, and judging by the folder, it did not go peacefully. The judge asks how he pleads. It is the simplest question in the room, guilty or not guilty. Arthur does not answer because apparently that would be far too direct. He looks down at the summons, then up at the bench, and says he is not Arthur Pendleton. That name, he says, is a corporate trust, a dead legal fiction, a name printed in capital letters. He is Arthur, of the family Pendleton, a living man, appearing by special visitation and not by consent. In other words, the person standing exactly where Arthur Pendleton was asked to stand would very much like to discuss why Arthur Pendleton is not technically present, which, as courtroom strategies go, is certainly one of them. It is not so much a plea as a customer service complaint addressed to reality. A small silence opens in the courtroom. The judge pauses not because the argument is new, but because everyone can sense where this is going. This is the first move in the sovereign citizen script. Separate the person from the name. The court is trying to establish identity. Arthur is trying to fracture it. The judge brings him back to the charge. Arthur pushes the case outward to punctuation, capital letters, hidden contracts, and the idea that the man in the dock is not the person on the paper. It is a bold strategy. Deny the paperwork while also arriving with a folder full of paperwork that supposedly proves the paperwork is the problem. It is like bringing a cake to court to argue that flour does not exist, and then demanding that the judge acknowledge the sponge layer's sovereign rights. Then comes the next familiar claim. He was not driving, he was traveling. The word lands carefully as if it has been rehearsed. In sovereign citizen belief, driving is reframed as a commercial act, while traveling is treated as a natural right. Arthur says he was moving privately, peacefully in his own conveyance. The judge does not follow him into that maze. He returns to the facts. a public road, a motor vehicle, no required license, no registration. Apparently, the vehicle did not become less of a vehicle because someone renamed the journey. My washing machine also travels across the kitchen during the spin cycle, but I still would not put it on the M6. Although, to be fair, it probably has more road sense. Arthur opens the folder. The sound is small, but in the quiet room it feels theatrical. Paper sliding against paper, plastic tabs snapping back, a breath held too long. He removes a document covered in red ink, thumbprints, postage stamps, colons, and hyphens. He calls it an acceptance for value. To him, it is not just paper. It is a financial instrument, a notice, a weapon. He believes it can settle the debt of his straw man through a secret account. The judge sees something else entirely, a document with no legal effect. A less generous observer might call it stationery with ambitions, the sort of document that arrives looking as if it has already been represented in 3 tribunals and lost. And this is where you can feel the tension rise. Arthur and the judge are now speaking from different realities. Arthur believes every phrase is forcing the court to prove authority, accept liability, or reveal the hidden fraud. The judge hears a man refusing to answer the only question before the court. Arthur repeats that he does not consent. The judge warns him that a plea can be entered on his behalf. Arthur grips the folder tighter. The words sound like a charm, but they do not stop the proceedings. A not guilty plea is entered. A trial date is set. He is advised to get proper legal advice, and just like that, the spell fails. Courtroom reality wins, not because it is louder, but because public law does not vanish when someone refuses consent. Shocking, I know. The legal system does not come with a hidden unsubscribe button, a secret opt-out clause, or a customer services department for metaphysical objections. The paperwork may feel powerful in a Telegram group or a hotel seminar. In court, it becomes evidence of confusion, not a key to freedom. The judge does not say, "Ah, yes, the hyphen, we are powerless," nor does the clerk whisper, "My lord, he has used red ink, we must retreat." Act 9, The Paper Sword. When I look back at David Wynn Miller, I see a man who looked at language and saw chains. His followers looked at his language and saw keys. But from the skeptical distance of the courtroom record, the doors they were trying to open were never locked by grammar. The sovereign citizen movement thrives because it offers freedom without compromise, power without institutions, and justice without ordinary law. It turns legal complexity into a monster, and then sells a map through the monster's house. That map is wrong, but it is emotionally useful. And in the digital age, emotionally useful falsehoods can travel faster than corrections, especially when the falsehood comes with a template, a slogan, and the confidence of someone who has never successfully used it in court, which inconveniently is not usually printed on the brochure. After Miller's death in 2018, the movement no longer needed him as a living leader. It had already absorbed the method, reinterpret the world as fraud, recast paperwork as magic, and transform defeat into evidence that the conspiracy is real. The tragedy is that the sword is made of paper. It does not cut through the system. It usually cuts back into the person holding it. Closing, what the movement reveals. By the end of this story, I do not think we can explain the sovereign citizen movement by simply calling it irrational. Legally, its arguments fail. But emotionally, they tell us something important. People reach for these ideas when ordinary systems feel impossible to understand, impossible to challenge, and impossible to survive. They are looking for explanations. They are looking for control. And sometimes they are looking for a community that will tell them their fear means they have finally seen the truth. David Wynn Miller gave that search a grammar. Not a valid one, not a useful one, but a grammar nonetheless, a way to arrange fear, grievance, humiliation, and distrust into something that felt like a revelation, a way to make chaos feel coded, a way to turn panic into paperwork. And that, I think, is the warning. When people lose faith in institutions, they do not simply stop believing. Sometimes they believe harder. They believe in secret laws, hidden contracts, capital letters, ancient clauses, paper swords, and men who claim punctuation can set them free, which is a lot of responsibility to place on a colon. So if this episode has raised questions for you, I want to end somewhere practical and safe. Not with a template from social media, not with a guru in a live stream, not with a document covered in stamps and certainty, Start with qualified legal advice, debt advice, housing advice, or support from recognized services. The law is complicated enough. Pretending it is magic only makes it more dangerous. So the next time someone tells you they have found the secret clause, the hidden account, the ancient right, the magic wording, or the punctuation mark that brings the system to its knees, listen carefully, not because the claim is true, because the need behind it may be real. Somewhere behind the paper kingdom, there is often fear, debt, anger, humiliation, or a desperate wish to feel powerful again. That is why the myth matters to me. Not because colons can defeat courts, not because stamps can discharge debts, not because a name in capital letters opens a portal to a corporate shadow self. It matters because people keep reaching for it when ordinary systems feel too cold, too confusing, or too far away to help. And when people are reaching, someone will always try to sell them a rope. And that, for me, is the final irony of the paper law myth. It promises escape from the system, but it often traps people deeper inside it. The notices get filed, the stamps get pressed, the words get recited, and still the court date arrives. The bill comes due, the door never opens. No secret handle, no hidden latch, no magic phrase whispered into the margins, just paper, pressure, and consequences. Because in the end, the law is not a riddle solved by punctuation. It is a human system, flawed, powerful, sometimes unfair, often intimidating, but not imaginary. And the people selling secret keys to it are usually not unlocking anything. They are selling the key ring, possibly on a subscription plan, with a bonus webinar and 3 downloadable PDFs. When the world feels impossible to fight, be careful of anyone selling you a shortcut made of paper. So here is my final call to action. If this story stayed with you, share it with one person who might recognize these arguments before they get pulled too far in. Like the episode, subscribe to the show, and leave a comment with your thoughts, especially if you have seen this kind of paper law mythology online, in court clips, or in your own community. And if you recognize any of these ideas in your own life, your family, or your community, pause before the next template, the next guru, or the next secret filing. Talk to a qualified advisor. Ask for evidence. Check the source. Because skepticism is not cynicism. Sometimes it is the thing that keeps the door from closing behind you. Thank you for listening, for thinking critically with me, and for spending this time inside one of the stranger paper kingdoms of modern belief. Until next time, stay curious, stay skeptical, and do not let anyone sell you a secret key to a door that was never locked, especially if the key arrives by PDF. I'm Bernette, and this has been Bernette's Bizarre but True Tales.